All right. Well, thank you very much for the opportunity to present in this session. I'm really sorry that I'm not there really to present in person, but I'm going to try to do my best to um, um, be that boring about this topic. Well, the presentation is about institutional experimentation on platform work, and I'm basically exploring the cases of Spain and Chile as cases of institutional experimentation. This is a part of a broader project of my PhD research. So one of the papers of my PhD is basically about these two cases as cases of institutional experimentation. The first point that I would like to maybe try to emphasize is why Spain, Chile. Um, I would say that both countries have been um, becoming like policy benchmarks in their respective regions. Europe, in the case of Spain, and South America, in the case of Chile, in terms of the new regulations that have been enacted on platform work. In the case of Spain, we have the rider law that was enacted in 2021. It introduced actually a presumption of employment for riders working for delivery companies. And it mandates as well the creation of an algorithmic committee at the firm level involving union participation in these committees as well. In the case of Chile, we don't have an employment presumption in the new regulation. Basically, what the new regulation do is basically to add like a new category of self-employed worker, but within the labor code. So basically, there are now two regimes in which the platform worker can maybe can either like join the self-employed regime or the employee regime within the labor code. In both, of course, there is like a kind of minimum social security rights, but they're different in terms of the other kind of regulations that are applied to them. This regulation also targets like a wider group of platforms. It's not just for delivery workers, as the case of Spain, but also all the what we will call as on-site platforms, ride hailing, the cleaning sector as well. So in that regard, quite different regulations. But the two research questions that I present here are why and how do actors decide to experiment with special regulations on platform work? Why to regulate in a different way or to enact new regulations on this matter instead of just enforcing pre-existing regulations? And what are the scope and the lessons learned from each experience? So basically, what I want to do in this paper is try to apply the institutional experimentation approach to these two cases to explore how the process unfolds over time in both countries. Why I think that it's important to use this framework. First of all, because I think that there is an interesting critique about the institutional change debates. This approach allows to adopt like a kind of more meso level, contingent, localized kind of approach. There is also an argument that is quite interesting from Caitlin Thelen about that it's not only about the institutional differences that we have in each country. In this case, Chile and Spain are quite different as well, but it's also about the different flashpoints that in each country are coming to the forefront. I mean, the different battles that at the end frame the debate in each country are different as well. And there's also a third point about the kind of uncertainty that the actors face when it comes to regulate new sectors or new markets. So this kind of new space for creativity of the actors is also a really important point of view. So basically, the experimentation approach is trying to first identify what are the the challengers and the cognitive and real world challenges, what are the strategies that the actors adopt, what are the organizational institutional resources, the coalition building process in each case, what kind of experiments we have at the end in each case, and what are the implications in terms of enforcement, and what's at the end the general overview that we have about each case. In terms of the methodology, as I said, the research is part of a broader project of my PhD thesis, which combines basically different qualitative methods. Part of that is basically based on interviews. I've been interviewing around 25 key actors in Spain and the same amount in Chile. People from the labor inspection, people from trade union officials, people from the government, and at the same time, we've been analyzing different kind of documentary sources, considering legal judgments, court rulings, documents from companies, policy reports, and also different kind of press resources. So in terms of the analysis, maybe I would like to try to organize this analysis following the experimentation approach framework. So the first part is about the cognitive framing and the strategies in each case. In the case of Spain, what we had is like early in this debate, the transportation sector was regulated by basically they partnered with the companies in charge of to manage the license, the driving licenses, something that actually was mentioned in one of the presentations. So basically, the main target of the new regulatory debate in Spain was really the delivery sector or the riders. And the problem of bogus self-employment was mainly the main approach in this case. There was two different kind of groups in this debate that deployed different strategies. One of them was the work between unions and some writers, collectives or indie unions pursuing strategic litigation, and also they work with the labor inspection. And on the other hand, there was like a sort of alliance between companies and rider groups. They first experimented with the third category, actually, that is available in Spanish labor law. Through they try to basically enforce or apply these new regulations through company agreements between the riders groups and the companies. The case of Chile is quite different because all the platform mediated forms of work were understood as a new form of work. So basically the pre-existing regulations was not enforced, not even in the transportation sector. And because of the diversity of different types of work that are like that were emerging back then, and the difficulties of trying to come up with a kind of solution in terms of the employment relationship, the debate was more focused about the problem of the access of social security, regardless the employment status of these workers. So the problem was framed differently, basically. And the strategies were more state-led at the end. Early attempts of litigation from the workers were not really successful. So basically, what the government did was present some bills to the parliament, and through that process, there were some kind of spaces of social dialogue in which the different actors or stakeholders participated to try to come up with a new regulation. But it took years to really agree on something about this point. In terms of the organizational and institutional resources, in the case of Spain, we see that actors basically draw on different resources. Workers basically work with trade unions. The labor inspectorate was quite important in the case of Spain, and it's been still a quite important institution for this debate. And the courts as well, a lot of court rulings said that basically these workers should be classified as employees. So that set like a precedent that is quite important in the Spanish story. The companies did the same to some extent because they organized social movements in favor of the self-employment status of the workers, and they also won different cases in courts as well. So basically what the state did was trying to create a space for social dialogue in this case. But because of the interest of these two sectors, unions and some writers groups on the one hand, and the companies and some other writers groups on the other hand, the collision of interest was quite big, basically, in the case of Spain. So the agreement was at the end quite narrow. It was just about writers, even though that the workers at the end really wanted to enact a new regulation covering all the new forms of platform work. It was only about writers at the end. But at the end, basically, what the law is doing in Spain is basically ratifying what the labor inspection and the courts were already saying, that these workers should be classified as employees. In the case of Chile, again, we see some differences because the agency of the actors was rather confined to the institutional space, because it was basically from the parliament that the spaces of social dialogue were created. And basically in this kind of space create the context in which the main actors, especially from the government, highlighted the agreements that were basically the need of social security, and they dismissed basically the disagreements that was basically around the idea of the employment status of the workers. So I think that at the end, in the case of Chile, the technocratic belief that this kind of work is a kind of special, a new form of work imposed to some extent in the debate or in the public debate, and a really like an anomaly in labor law happened or took place in Chile because a new self-employed worker category was introduced within the labor code, which is the main instrument or legal instrument that covers the regulation of the employment relationship in the Chilean context. So it's quite like contradictory in itself, the solution. And then in terms of enforcement and the framing ex post, what we have in Spain is like after the enactment of this new regulation, we see some partial compliance. Platforms have been responding in different ways, from exit, as the case of Deliveroo, to outsourcing, especially Just Eat. It's been promoting the use of outsourcing and subcontracting as a new way to comply with the idea of the presumption of employment, but basically reallocating the responsibility of employing these workers to the third-party companies.
Just 2 minutes.
Right, thank you. Some other companies have been basically hiring directly the companies, but this is definitely a minority of the cases. So I think that at the end, what happened is like the labor inspection and different industrial relations actors gained some ground in this debate in Spain, and they've been able to tackle these kind of raw new employers, but there is still some big enforcement gaps in the way that the regulation is working. In the case of Chile, what we have is basically an unchecked compliance. There is no proof that the companies are really respecting the way that the regulation is framed, because the way that the regulation is framed is quite ambiguous. Like this idea that you can be either a self-employed worker or an employee within the labor code ended up being a way for the companies to exit the labor law, and basically workers are quite compelled to just be classified as self-employed workers. So just for the main conclusion or discussion conclusion of this point, I think that the case of Spain and Chile are quite like two archetypes of regulatory experimentation in platform work. In the case of Spain, the solution is quite narrow in terms of the target of the workers, but they extend labor rights basically. Whereas in the case of Chile, the solution is broader because it targets different types of workers, but it creates an exceptional category within the labor code, which also is further fragmentation of the regulation, of course. The outcomes are different because of the problem is framed different. In one case, they decided to enforce pre-existing regulation, whereas in the other case, they neglect that option and they opted for new regulations. The dynamic of participation is quite different as well. In the case of Chile, it was more kind of a top-down organization of the process, whereas in the case of Spain, it was more kind of a bottom-up effort. And I think that that's also a proof that in the case of Spain is a more kind of emergent solution from the conflict first to the institutions, whereas in the case of Chile is a more kind of deliberate solution from the government to the bottom. I think that just to close, the ultimate outcomes of the experimentation cannot be anticipated. For instance, what is happening now in Spain about the subcontracting trends and that kind of things are quite novel to some extent. But I think that also the research shows some limitations of the experimentation approach, because one thing is that the role of the state is working in different ways, because not all the regulations are really fitting in just one good or coherent regulatory framework. So the fragmentation is increasing in that regard. And the second point is about the role of employers, because at the end, the employers still have some exit options even after these experimentation experiences. So I think that more research is needed in that point as well. Thank you.